All right, good afternoon, everyone. Thank you for coming along to today's session. My name's Andrew Yarl. I'm a special counsel in the Workplace Law and Culture team. And with me today is Eric Kwan, a special counsel as well, who works in the corporate and commercial team here at Bardia Perry. We're looking forward to speaking to you today about share equity, share schemes, equity arrangements, and other reward structures, and running through some key considerations, benefits, and recent legislative changes that you should be aware of. But I'd like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of this land. I pay my respects to their elders past and present, and I recognise their continuing connection to our land, waters and culture. I extend my respect to the Aboriginal and Torres Strait Islander peoples here today. I'll now hand over to Eric.
Thank you, Andrew. So in this webinar, I will be talking about employee share schemes, in particular what they are, how they work, and what to look out for from a corporate lawyer's perspective. Andrew, as he said before, will be talking about the benefits and pitfalls of employee reward schemes generally, including bonuses, commissions, incentive schemes and whatnot, as well as some of the recent legislative changes which impact confidentiality and result in workplace cultural considerations. We won't be talking about the tax or the implications this has in relation to employee incentive arrangements. This is something that you really do need to talk with a tax accountant or a tax lawyer about, but it is, I guess, useful to recognise the fact that tax does have a role in influencing how employee share schemes are designed. Okay. Talking from a business perspective first and foremost, employee share schemes come in various shapes and sizes, and you will have heard of some of these at some point in time. Firstly, you have the more traditional employee share scheme arrangement, which is sometimes called an employee share purchase plan. This is where you have a headline scheme or plan through which you can issue to your employees or directors shares in the company. These shares will be subject to the terms and conditions in the share scheme plan, and as well as the constitution and shareholders agreement if you have one in place. A slight variation of this is the employee share option scheme. Under this sort of arrangement, you do also have a headline scheme or plan, but you will be issuing share options to employees. What this effectively means is that the employees can exercise those options once the relevant conditions are met and buy the shares from the company. A further variation of this is what is called a performance rights plan. Here, rather than issuing options, you are issuing performance rights. The distinction really is that these performance rights don't give any rights to shares as such. They are designed, though, to convert automatically once certain conditions are met. The alternative is what may be called a phantom share plan. This is where you might issue phantom shares, and depending on how the scheme is structured, those phantom shares will generally not be considered in shares or in interest in shares. They are, however, designed entirely to mimic how actual shares would perform. So they would normally attach themselves, dividend rights, capital gains, or something along those lines. There are, of course, other similar styled arrangements out there, and businesses over time have gotten creative because there is always a need to balance the tensions that we'll talk about later down the track. Now, from a lawyer's perspective, and I guess more specifically a corporate lawyer's perspective, an employee share scheme is something which fits the definition of Section 1100 and L1 of the Corporations Act, which is, to paraphrase the definition, a scheme under which an ESS interest may be issued, sold, or transferred to an employee or a director or an associate of theirs. it is useful at this stage just to recognise that there is another definition that is legislated under the Income Tax Assessment Act of 1997. However, for this session though, I will be focusing primarily on the definition under the Corporations Act. When it comes to designing an employee share scheme, there are a variety of different factors that need to be considered when you go about designing and implementing these schemes, which can make it a fairly difficult or complicated affair. Broadly speaking, though, these considerations typically fit into one of three baskets. You have the business or employment basket, the corporate, as well as the tax, in the sense that any ESS interest received will be considered a part of the employee's remuneration. Looking at each one of these a little bit closely. As a business owner, there may be a number of business or commercial reasons why you may want to issue shares or other form of equity to an employee or director. To identify some of these, or at least some of the more usual reasons why you would go about issuing shares, shares or equity schemes do allow businesses to offer employees something other than cash. This can be important, especially where there might not be sufficient free cash flow to support, say, a bonus payment, or where, I guess, cash is not so much an incentive, or you simply cannot pay enough cash to incentivize someone properly. Another reason why you might look or turn to employee share schemes is that it does improve alignment of employee interests with those of business owners, because at the end of the day, you do create a direct correlation between the value an employee is generating, which is, I guess, usually in the form of revenues or profits, and what the employee ultimately receives, and this in turn turns into dividends and capital growth. Another reason that you might turn to share schemes is because it might be part of your succession planning processes. For example, you may want an employee to gradually build their portfolio in the company, and which would then allow for the main or the primary business owner to gradually dilute themselves down and exit the company. Okay, turning to the corporate law perspective. Now, there are two main issues that do need to be considered here, and these primarily revolve around the definition in the Corporations Act. Firstly, is the scheme an employee share scheme for the purposes of the Corporations Act? And secondly, does the issue comply with, or is it made in line with, Part 712, Division 1A of the Corps Act? These are important questions to ask, because under the Corporations Act, there are a variety of different controls and regulations which manage or regulate how or who offers shares in companies for sale. This, I guess, regime works over and above what is provided for in a constitution, and for the most part, these controls aren't particularly relevant when we talk about the issue of shares under an employee share scheme. Okay, so turning back to the definition, and really just to look carefully at this definition, there are a few elements that I wanted to draw out. Firstly, you do need to have a body corporate. Secondly, you need to have a scheme. This concept is fairly broad and does look to the general dictionary definition. Thirdly, this the share issue does need to involve the issue of what's called ESS interests. And these are, generally speaking, employee shares, options, incentive rights, and units. But the definition, I guess, can be a bit more expensive than that. And then finally, you do need to be issuing shares or ESS interests to an employee or a director that is, or someone or entity that is related to one. So if you are comfortable that your scheme would be considered an employee share scheme, then the next question really is to see whether the issue itself is made under Part 712, Division 1A of the Corporations Act. Generally speaking, the issue will be covered or be made under that division if that issue is received in Australia and either it is for no monetary consideration, as in it's being issued for free, effectively, or if there is to be monetary consideration involved, that the issue does not cause the issue cap to be breached. The terms of the issue comply with sections 1100Y and Z, and the offer complies with the disclosure requirements under 1100W. Additionally, if the company is not listed, then you do need to provide information prescribed in section 1100X, and the issue itself must not cause the monetary cap to be breached. Looking at each of these a little bit more closely. So, to be considered an issue under Part 712 Division 1A, the issue itself cannot cause the issue cap to be breached. What this means is that the number of shares issued plus the number of shares that could be issued over the next 3 years cannot exceed 5% if you are a listed company or 20% otherwise. This does make it a little bit more important to try and keep track of all the share issues or the option issues that you do make, especially if you do make, if you are interested or looking at doing a mixed offering. The next criterion is that the offer itself needs to include the specific requirements under section 1100Y. Under this, you do need to offer what I normally call a 14-day cooling off period, so that employees cannot exercise or take up an offer within 14 days after they receive the offer. And additionally, the full terms of the offer or a summary of those terms need to be included in the offer documents. And if you are looking at providing only a summary, then you also need to provide full documents within 10 business days. If one of the things that you are including in this arrangement is a loan or some form of employer trust arrangement, then either these full documents need to be provided or a summary, which, along with the terms, need to be provided within 10 business days of request. Now, for unlisted companies, there is an additional requirement that, especially for those involving the issue of share options or incentive rights for monetary consideration, that the 14-day cooling off period starts after the options are exercised as well, or 14 days before the options are exercisable. And there is an obligation to provide additional documentation. Under section 1100Z, the terms must not include misleading or deceptive statements or omit anything that could be construed as being misleading or deceptive in any way. Additionally, terms must be included to require the company to provide updated documents should it become aware that information that they have provided is outdated or is simply not correct in any material way. depending on what these statements are, there may be personal liability responsibility for directors, including shadow directors and individuals who are named in those documents with their consent. This is, of course, subject to certain conditions being met. ASIC do also have wide-ranging powers to, I guess, amongst other things, declare modification and issue stop orders to prevent the offer, issue, or sale of these interests. Looking at section 1100W, now this prescribes certain disclosure requirements and they are fairly prescriptive, but largely fit in with the terms that we've already discussed before. So as you can see, we are talking about including the full offer terms or a summary. We also need to include a general information piece about the fact that there is risk associated with acquiring and holding shares or ESS interest. You also need to include an express statement about the fact that any advice that is in these documents doesn't take into account individual interests or individual needs or objectives. There also needs to be an express statement suggesting that the employee seek their own legal and financial advice. And it does need to specify in writing the period in which the offer itself may be accepted. And further, I guess if there are loans or trust arrangements involved, then they do need to accommodate for these arrangements. There are, I guess, additional requirements depending on whether or not you are talking about a listed company. And this, I guess, involves setting out in some detail the acquisition price itself or how you actually ascertain this acquisition price, as well as an explanation about how the employee participant may ascertain the price of the shares or interests. For unlisted companies, there does need to be an express statement that the interests might not have any value or that any value might depend on future events happening. And I guess if the interests themselves aren't ordinary shares, then you do also need to include a description about what rights to attach to those interests, as well as how they differ from ordinary shares generally. In addition to before, and as I said before, unlisted companies do need to provide what are called supporting information, and this includes financial information, which translates normally to financial statements. They also need to provide valuation information, which is normally in the form of a formal valuation that has been prepared in accordance with approved methods, a disclosure statement, which has been lodged in relation to that same share class, or copies or draft documents that have been agreed for securities in that same class. Additionally, you do need to prepare or submit a solvency statement, which translates to a statement by the company that it is able to pay its debts as and when they become due and payable. It is probably useful just to remind ourselves at this stage that there is personal liability for directors and persons named in documents, to make sure that offerings and offer documents do not contain anything or omit anything which could be considered misleading or deceptive. Practically speaking, what it does mean is that when you go about compiling these documents, you do need to undertake a verification process, much like you might do with a prospectus document, just to make sure that anything you do say in the offer documents is not misleading or deceptive in any way. The final criterion in all of this is to make sure that the monetary cap is not breached, and as you can see on the screen, the cap constitutes $30,000 plus 70% of the distributions made during that period, 70% of any cash bonuses that have been paid, and any unused cap during that same period. Putting aside the Corporations Act and Part 712, Division 1A, there are a number of broader scope issues that do need to be considered from a corporate law perspective. These are just some of the issues that you might want to think about. To talk through these rather briefly, you do have the question about decision-making and control, or I guess more to the point, whether or not you involve the employees in some shape or form in the decision-making process. There are, I guess, a number of factors that might form your decision here, such as whether or not the individual is receiving a substantial proportion of shares, how senior the individual is, and I guess whether that individual is even interested or has the skill sets to partake in that process. Another thing you might want to focus on is really the shareholders agreement and what's required there. It might also, I guess, burgeon the question as to whether you need a shareholders agreement in the first place. Another question that you might want to consider is how the issue of shares might fit within your director's duties. In particular, whether or not it is in the best interest of the company to do this. Funding is also typically another issue or question that pops up, because if you are issuing shares or interests to employees for fee, employees may not be able to simply take money out of the bank to pay for these shares. There are a number of ways that the company can help fund the payment or the purchase of the shares, but it does mean that you do need to think about whether or not you do have obligation under Part 2J of the Corporations Act in relation to financial assistance or the provision of financial assistance. There are also issues about confidentiality and privacy, because as shareholders and as directors, potentially employees can get additional access to information about the business and sometimes about their colleagues in the workforce. But I might leave that discussion for Andrew to talk about. And on that note, I will pass it to Andrew.
Thanks. Yeah, so as you can see, there's a lot to consider from Eric's side of things, and just like Eric, there's a lot to consider from the employment side of things as well. So during my presentation, my part of the presentation, we'll consider remuneration generally as a concept, allowances and benefits, bonuses and commissions, together with considerations, risks and insights into all of those, but primarily focusing on points 3 and 4 on that slide. We'll also look at changes brought in by the Labor government in 2022, which impact on confidentiality requirements around REM, and which has a broad interpretation. And we look at considerations that could have on culture and broader impacts on organisational strategy. So common rewards for work. We'll start with a quick overview of remuneration generally. As share schemes or incentives supplement ordinary remuneration, and therefore that will dictate how much needs to be offered by way of incentive or bonus to entice the right employees to the workplace. Allowances or benefits, which can include non-financial components like motor vehicles or gym memberships. Bonuses, they can be paid periodically, like yearly or quarterly. And there's also considerations around short-term incentives or long-term incentives, again, depending on what you're hoping to achieve by implementing such schemes. And they can be linked to matters that are within the employee's control, like them achieving their own KPIs, or matters that are outside of their control to some degree, for example, overall organisational performance, or it can be a combination of the two. And then commissions are, of course, a common way of rewarding employees too, and they're common in industries like the sales industry. So, of course, remuneration is the most common form of reward for employees. That is, that employees expect to be paid for their work. It's also important to the legal deal being struck, as a contract of employment requires consideration, just like any other contract, being obligations on both sides of it, to be enforceable and operative. REM can also be included in industrial instruments, which we say always that shouldn't be contractually incorporated, but do operate as a matter of law. And contractual matters, of course, need to be observed by the employer in the employment relationship, as well as the employee, of course. And if they're not followed, there could be a breach of contract, which could lead to damages, or could also have other impacts like post-employment restraints not being operative. And in that regard, if it's considered that an employer has repudiated a contract by their action, then the argument could be that the employee is released from their post-employment restraints, like non-competes or non-solicitation. In terms of repudiated conduct as a concept, the courts have said it's conduct of a party which evinces an unwillingness or inability to render substantial performance of a contract, or which evinces an intention no longer to be bound by the contract, or to fulfill it only in a way or manner that is substantially inconsistent with the party's obligations. And in that regard, we'll come to concepts shortly around contractual incorporation of schemes, and how an employer could fall afoul of those principles and therefore lead to broader implications by way of damages or a lack of enforcement of other obligations. In terms of the reason for offering bonuses and commissions, it's obviously an organisational one, but it might be to try to keep up with the industry you operate in. As I say, for example, the sales industry. It might be to make an offer more attractive to staff to come to your firm, or to keep them at your organisation. It may also be to incentivise people to work harder because they're getting something directly for their effort in working, or putting the effort in. So as employment lawyers at Barty Perry, who primarily assist employers, would always recommend that a bonus or incentive scheme is discretionary and in policy only, that sits outside the employment contract. But depending on the industry and purpose of the scheme, it may be that as an organisation you do want to make it contractual. Again, that'll be dependent on your circumstances. But there are also general considerations as to whether a policy could be found to be contractual. And there are some factors to consider in that regard. The general principle at a high level is that the employment contract incorporates, as part of its express terms, promises that are made in external material, which could include policies, when a reasonable person would think that the policy was intended to be contractually binding. So it turns on the intentions objectively determined from the circumstances. And two important factors in that consideration are, of course, the language used in the contract and the document's nature and subject matter. So the document, let's say a policy, could be found to be incorporated if the language in which the parties refer to it reflects an intention to offer and accept mutual obligations. But it's important too that the external document doesn't include or has specific benefits, rather than imprecise or vague statements. There are other relevant factors which might depend on the circumstances generally, but could include things like whether the external document was provided at the time the offer was made, or at all, whether it was provided at all to the employee, whether the employee was required to read and acknowledge the external document in writing, and whether the external document confirmed a benefit that would ordinarily be included in contracts. However, the express words of the contract can also tell against incorporation. So if the employment contract expressly excludes incorporation, then that will largely be observed. It'll be a matter of contractual construction. As I say, it's always our recommendation that a policy would not be incorporated, which gives the employer more leeway to amend it or apply it in certain circumstances, but it might be an it's an organisational call. We do refer to that case on the screen there, Farrell and Shoeswell HealthLink from 2021. This case considered whether a commission scheme was incorporated into a contract of employment. The commission scheme was included in an external policy to the contract. There are also a number of other matters at play in this case, I should say, but we're obviously focusing on the commissions and incorporations point. The policy clause in that contract said you're required to comply with all of the employer's policies and procedures as instructed or amended from time to time, whilst applying to you the policies and guidelines are not incorporated in this contract and do not create enforceable contractual rights for you. So referring to case of the full federal court and that toll matter that's also on the screen there, the court said that these words were objectively clear and that the employment contract did not include the policies. And for those reasons, the commission policy that applied to this employee did not have contractual force, and therefore the employee could not sue on that policy. So a question that needs to be asked, which I've alluded to, is what is the purpose of the scheme you're seeking to implement? It's an important question to ask because it may shape how the scheme is framed by you in a legal sense and how it's sold to staff and implemented. It might impact on how the scheme or incentive is also interpreted to apply if an employee makes a claim. It may influence how the business wants to offer the scheme, whether in policy or contract, and therefore could be more a cultural business consideration based on the target employees in the market in which you work. But there might be a number of purposes or considerations in that thought process. So does it form part of remuneration? It might be that for example, I keep referring to sales employee, but most of their take-home pay might be in commissions, and therefore the base salary might only be a small proportion of take-home pay, and therefore the scheme might be more seen as remuneration, and it might be that the industry requires it to be contractual to attract the right staff. Or like I've mentioned, is it a reward to drive performance? Or perhaps it's to keep up with industry expectations, which links to what I was just saying earlier. And again, perhaps it's to attract and retain the best staff or instill commitment to the business. There's also the possibility for these purposes to impact on enforceability, like I said earlier, obviously depending on the terms of the contract and circumstances surrounding that. But if paid as remuneration, then it could be found to be contractual and enforceable unless expressly excluded. If paid to drive performance, enforceability may turn on the description and implementation of the scheme in practice. So generally, it would be in the employer's best interests, whether it's in policy or in contract, to have it discretionary. Like I say there, if it's entirely discretionary, it's unlikely to be found to be contractual if treated as such, but there are considerations in that regard. And in that respect, we'll turn to the case of Silverbrook Research and Lindley from 2010. It's helpful in considering discretionary bonus schemes and issues that arise under contract. So the applicant in this case was the business development strategist and started working on a salary of $210,000 in 2003. In addition to the annual remuneration reviews, she was also entitled to under the contract to an annual performance bonus of up to $40,000. And the relevant clause provided, and I'll read it out to you just so you understand the terms of it was operating. So the employee will be eligible to receive the bonus subject to clauses 4.2 and 4.3. The employer will assess the employee's performance against set objectives at the end of each quarter, commencing from the date of her employment. Provided the performance satisfies the set objectives and subject to clause 4.3, 1 quarter of the bonus will be paid to the employee within 21 days of the end of each quarter. Clause 4.3 then says the decision as to whether the employee should receive the bonus is entirely discretionary, is entirely within the discretion of Silverbrook. The employee must be within the employer of the employer at the time the bonus is determined. So the clause was found to mean by the Court of Appeal that the employer had promised the employee that it would establish a set of objectives at the end of each quarter. It would assess the employee's performance against those objectives, and subject to its discretion in 4.3, if the objectives were satisfied, the bonus would be paid in accordance with those terms. But it ultimately wasn't a promise to pay the bonus. The employee was promised the setting up and undertaking of a process of assessment of her performance with the contractual opportunity or chance of obtaining a bonus should the results of that process be favourable to her and subject to the exercise of the discretion of the employer. So the terms of the contract, like I've just read out there, were that it was at the employer's complete discretion. However, as you can see from the statement on the screen there, it wasn't the decision of the case, despite the words said. So in that regard, the court said the decision as to whether the respondent should receive the bonus was entirely within the discretion of the appellant, should not be construed so as to permit the appellant to withhold the bonus capriciously or arbitrarily or unreasonably. It should not be construed so as to give the appellant a free choice as to whether to perform or not perform a contractual obligation. The relevant discretion should be understood against a proper scope and content of the contract. This was a bargain for bonus to be assessed against set objectives, and it should receive reasonable construction, the clause. So basically, Silverbrook had thought it could just operate however it liked, but the contract does need to be considered within the context, and the discretion does need to be properly exercised. And in that regard, the court went on to say that it must be exercised honestly and consistently and within the purposes of the contract, stating that there may be many circumstances in which it could be legitimate and conformable with the purpose of the contract not to pay the bonus. So I think this is important. So, for example, the court says there might be financial constraints or there might be misbehaviour from the employee, but basically that there needs to be proper reasons for not exercising the discretion in those circumstances. And so if we pause here for a moment and think about the different purposes for reward that we were discussing previously, if the purpose is to keep the employee devoted to the business and productive, but the employee is in their notice period, then would it be capricious, arbitrary, or unreasonable to withhold the bonus in those circumstances? We wouldn't think so, but it obviously would turn on the precise terms of the contract and scheme. But if the bonus is intended to reward the employee for their effort in performance, and if they've already made sales, let's say, would it be capricious, arbitrary, or unreasonable to withhold the discretionary bonus in those circumstances, regardless of whether they're in their notice period or not? You could see that being possible, again, depending on the terms of the scheme, because they've already fulfilled their end of the bargain, so to speak, and the purpose has been fulfilled. But again, yeah, it depends on the wording of the scheme and the circumstances. So we'll quickly turn to a 2022 case from the Fair Work Commission. It was a jurisdictional objection raised by an employer in relation to a general protections application. And there are a number of arguments, again, similar to the first case I spoke about, but obviously for this presentation, we'll focus on the commission scheme that was under consideration. The applicant in this case was the business manager of automotive finance and insurance sales, and was on a base salary plus commissions and fringe benefits. The commission clause provided that the employee was eligible to participate in the commission scheme, but commission payments were discretionary, and the scheme is no guarantee that the employee would receive a payment or incentive. That was expressly said in the contract. The contract also attached the commission scheme as a separate annexure to it. The respondent during the applicant's employment, appointed a second business manager to a position that was broadly similar to the applicant's position. And the submission from the applicant was that the appointment of that second manager was in breach of his contract because it would reduce his access to commission income. But it was rejected by the Commission, stating that whilst it was a contractual term between the parties, the employee was eligible to participate in the scheme. And whilst commissions were an element of his overall package, the contract expressly provided that commission income was payable at the sole discretion of the employer. The employee was contractually eligible to participate in the scheme, but was not contractually guaranteed of any level of commission income, even though he had a reasonable expectation that commissions would be paid according to the structure. And even if it was a contractual term, the commission income according to the structure was to be paid, the employer did not alter the eligibility requirements of the commission structure, and there's nothing in the contract to infer that there were terms that the employee was to be the sole person in that position and thereby have access to a larger pool of potential commissions, I should say. As I said previously, in this case, in the employment contract, it provided that commissions were to be payable at the sole discretion of the employer, which gives the employer some flexibility, but consideration needs to be given to the findings in Silverbrook too. And in that regard, you might have noticed there were only slight variations in the provisions in Silverbrook and in Bozina, this case on the screen here. And I suppose the first thing that should be said is that they're in entirely different jurisdictions. The Fair Work Commission and the Court of Appeal are, firstly, the Fair Work Commission is an administrative tribunal and the Court of Appeal is a proper court. And the cases were different in that there was a breach of contract case in the Court of Appeal and a general protections claim in the Commission, which may have impacted on the discussions in those cases. But leaving that aside, the clause in the Commission case was clearer, providing that there was no guarantee that payment would be received, as opposed to the Silverbrook clause, which provided that it was discretionary, but it didn't go that further step of saying there's no guarantee that a payment will be received. And whether that was decisive on these specific facts is obviously not clear and can't be reconciled given they're in different jurisdictions, but it is a notable difference in terms of what I've been discussing today. There are also different arguments, I should say, that the applicant in Bozina was arguing that the clause was breached because of the appointment of this additional manager, which impacted, he said, on the pool of income he could be eligible to obtain, whereas Silverbrook was a claim that the actual terms of the incentive scheme had been breached. So an area that does require discussion during this and consideration generally in your rewarding employees strategy in your organisation is pay secrecy changes that came into effect at the end of 2022. So it was often the case, as many of you would be aware, I'm sure, that employment contracts would commonly have that the employee cannot disclose their salary to anyone, or at least anyone within the staff group at where they work, maybe in their team or just generally at large in the organisation. The general rule for those clauses was to prevent discontentment within the workforce due to pay parity considerations, as there could be many reasons from an organisational perspective that one person may be paid more than another person, including the negotiations in recruitment. There might have been filling in a skills gap in the organisation and they needed to be attracted by a higher salary. There could just be many considerations. So employers had a reason to insist on those pay secrecy clauses. However, the pay secrecy changes bring into effect that an employer basically can't include those clauses anymore. And the reason for those changes was in response largely to gender pay gap statistics in Australia, and the pros were seen to improve employee satisfaction, morale and trust in their employer, increased retention and productivity, and risk management for discrimination claims. There are, of course, cons in this situation too, and considerations for us in this topic, because while, as I say, competitive salaries or incentives may be offered to attract staff who are high performers or filling a needs gap, the risk now arises that the reward schemes offered to one employee can be disclosed to others in the cohort in which they work or generally in the workplace. And the employer can't take disciplinary action against them for doing that or require them to comply with a clause that prevents them from doing that. So employees and future employees have the workplace right now to share or not share information about their pay or employment terms and conditions that would be needed to work out their pay. Employees may also ask another employee for this information. However, they can't be compelled to provide that information. There are some exceptions to this rule. So if an employment contract was entered into before the 7th of December 2022 and it contains the pay secrecy clause and it hasn't been varied since December 2022, then they do remain in effect. We've italicized on the slide there the hasn't been varied because while it's possible that a contract has been in place since the 7th of December 2022 and not varied in any way, that's of course possible. It seems unlikely for a lot of employees that they haven't received even a slight pay rise or a change in title, a change in location, a change in duties, or some other change to their employment contract in over 2 years, but it's possible. So they could be enforceable for those employees. If an employment contract was entered into prior to 7 December and doesn't contain a pay secrecy clause, the employee is protected. And if entered into after the 7th of December 2022, the contract must not contain a clause to that effect. And to the extent it does, it wouldn't be enforceable. So what remuneration is defined as in the Fair Work Act? Well, it's not defined at all. It's a broad concept, which generally would be taken to mean reward for services rendered. It would cover wages or salary, penalty rates, shift premiums, allowances, bonuses, commissions and incentives, and any other terms and conditions of employment reasonably necessary to define those terms. And that's from that second limb is from the provisions themselves. Employers need to carefully consider offering special payments and remuneration to individual employees or prospective employees because, as naturally may occur, other employees could demand similar payments, particularly in comparable roles. In that sense, it is critical in this topic to consider those parity arguments, and I suppose having an explanation for an employee who does feel they're being shortchanged as compared to their colleagues without, I suppose, breaching confidentiality or privacy to another employee as to why they were offered that higher salary and another employee wasn't. So as I've been saying, us as lawyers, primarily for employers, will always recommend that these schemes are kept in policy outside contract and discretion is maintained. This way, the employer is always able to amend or remove or decide how to best reward its employees moving forward. However, we appreciate, depending on the business and the circumstances, that might not fly for relevant employees. The discretionary no obligations policy outside the contract might simply just not give enough certainty to an employee for them to feel comfortable coming to your business. And now what overlays all these considerations are the pay secrecy prohibitions, which means the employees will talk and they legitimately can talk in the workplace. And as such, like I said, considerations of equity within cohorts and fair reward are critical. Otherwise, valued staff members might leave. They might feel genuinely unhappy at work, and that kind of discontentment in the workplace can lead to a raft of other issues like absenteeism, productivity issues, collaboration, and culture generally in your workplace can suffer with those issues in place. But in wrapping up the presentation, we thought it would be helpful to outline some considerations that we've been discussing today and to be drawn from some of the case law we've been looking at. So the starting position is, what is the purpose of your reward system? Is it an essential part of remuneration? Is it a reward scheme to drive performance or loyalty? Is there some combined or other purpose, industry standards, attraction of staff, attracting specific skill sets and the like? And depending on the purpose, it may change the way you manage it in policy or contracts and the terms of each. Then you need to consider whether an employee is just eligible or entitled. Is the employee only eligible, being that they may participate in the scheme, and then logically they may not participate in the scheme, and therefore they may not be entitled to, or not, they may not end up being entitled to receive any payment under the scheme? Or is that too uncertain and the entitlement must be, I suppose, firmed up a little more for an employee? If so, what are the criteria that should be included in any scheme to allow an employee to feel more certainty in that regard? And how should it be tied to performance or any other factor that the business thinks is appropriate? And then that, of course, leads to whether it should be contractual or not. Should it be a term of the contract? It might be that that is the most appropriate way for your business. But if that is the case, then it's important that careful drafting of the clause is undertaken, and then its strict adherence to the contractual obligations are also observed. If it's only mentioned in policy and not incorporated, and depending on the flexibility afforded in the policy, there may also be organisational considerations about the implementation of it from time to time and how to amend it in the future, whether to withhold in certain years for certain business reasons or economic reasons, or whether to pay in certain years despite employees not meeting targets. For example, if you have an employee who you're concerned about leaving, it might be an incentive to stay. In a similar vein, we have to think about discretion and keeping in mind the matters spoken about previously, that just because you say it's discretionary in a contract doesn't mean you can do whatever you like necessarily. But it is certainly something that brings some business comfort and flexibility if it is truly discretionary. But again, is that enough for the employee? In terms of quantum, we need to think about the calculation basis, of course, and it's a balancing act. So, for example, does the business think? So if we take a sales role again, do we calculate it on the basis of when the sales invoices are paid, or do we calculate it on the basis that the sales have been made? And in that sense, it's a business balancing act, I suppose. Should the employee be required to wear the risk of a client not paying, or is that reward actually offered for to drive performance or as part of remuneration, or to retain the employee, as opposed to the risk of a bad debt accruing from an employee? So should the risk lie with the employer or the employee in that circumstance? And consideration needs to be given to how clear and measurable KPIs are. And in that regard, non-financial KPIs are often difficult to measure, and if it is in a contract, can lead to disputation. So, for example, the employee will adhere to the company's values in all ways in working. If that was in the contract, for example, you could find yourself, and you withheld a bonus on that basis, you could find yourself in disputation about, well, what are those company values? Did the employee actually comply with them? Where's the evidence that they didn't, etc. So that can lead to disputation. So that's something to think about as well. And then think about qualifying terms. of course, I'm just not conscious of the time, so I might just run through these a little more quickly. Got to think about your qualifying terms, your disqualifying terms, what applies on termination of employment, and also in those periods of notice, is the employee still entitled to receive it? And if they're a good leaver, bad leaver. So, for example, if they're leaving under a misconduct investigation, should they really be receiving a bonus if they become eligible in that period? Those considerations are critical. And then variation, so the ability to vary the scheme, which relates to the discretion and other matters we've spoken about in that regard. And that brings us to the end of our presentation. We're available to take a couple of questions if there are any. There aren't any we can see on the screen there, so there may not be any. So we might bring our talk to a close then. Thank you everyone for attending today. We've enjoyed speaking to you, and we hope to see you next time at our seminars.
Thank you.